Hi, my name is Dan Fowler. I'm president of the Apartment Owners Association of California. We're one of the largest individually organized groups of apartment owners in the state, and there's a good reason for it. We have a goal. We have a goal for this webinar today, and we have a goal for our magazine. Every time you call in for consulting, we have a goal, and that goal is that you make and or keep more money than ever before. In addition to that, we hope to make your providing of housing to our tenants, the housing consumers, easier, more profitable, and more enjoyable. And we hope you get that one idea today. I know you will. We have a very special guest speaker who's going to give you idea after idea, so be sure to write them down. Write your questions down, because at the end of his talk, you'll be able to send in your questions. As you know, right now, the political gangsters are meeting to determine your fate, to determine what's going to happen during the next, 6 months before they change it again. Some of the things that they're looking at in this AB 1436, they're going to extend the eviction moratorium, of course, till probably April of 2021, and then at that time they'll consider extending it even further. Free to give you, of course they want to give away free rent, so they're going to force you to give away free rent, probably, continue that. Give the tenants, housing consumers, forever to pay you back, forever, which means free rent is what they want to give and buy. Of course, they buy votes that way, and so now they're using your property to buy those votes, and it's very profitable for them, saves them a lot of money in their campaigns. They're also talking about rental vouchers. Thanks to many of you who have written letters, you've signed the petition where we've asked for rental vouchers for the owners. This is the second best solution. Best solution is our American economic system of free enterprise where we have a free market. But number two solution, since they're not going to allow us that freedom, is to issue vouchers. And you've asked for it, you've demanded it, and they're talking about it. The problem is they're talking about it in a different form than what you requested. With these vouchers, they're probably going to ask that you forgive your renters of the past back rent. They'll ask you to forgive if you accept a voucher. So that's something most of you are going to want to be thinking about, whether or not you're going to take these vouchers and do that and forgive all the past rent or not. That's a decision that you'll have to make. You'll also need to get your renters to request the vouchers and get the vouchers to pay you, because some of them just think they get free rent. What do they need to do anything else? They'll just sit there through April 21 and do nothing, with some exceptions, and you're going to hear about that with our speaker today. So beware of this, that's coming up. It's about giving you tax credits is another item that's coming there. For the big owners, that's real good. For the small mom and pop owners, you can't eat tax credits, can you? And you can't pay the bills with that. You can't keep the lights on with that. And so that's something that is going to be detrimental to us as far as smaller owners if they give tax credits. The tenants are going to repay probably, one proposal is that they start repaying in the 2024. Another bright idea from people who are currently making more money than they've ever made in their life, working off the government, living off the government. Many of them have never had a regular job. They know how to do one thing very well, and that's get elected. And many of them did it at a very young age, and they're riding on you, and now they're even using your property to get reelected again and buy the votes of tenants. I'm going to ask you to take action. First of all, we have the petitions. I want you to go to aoausa.com/petition and sign those petitions. There's 2 petitions there if you haven't already signed a petition. You want to download that petition after you've signed it, download it and mail it. It's even more effective. Your emails are effective, but your letters are even more effective in going into the governor's office. You'll get more attention. So write a letter and send the letters in to the address that we'll show you on the screen, to the governor's office, and his helpers will get those letters and relay them to him. If we send in thousands of letters, they're going to pay attention. Many people say, well, they're not going to look at just my one letter. It's probably true. They're probably not going to look at one letter. But if they get a couple thousand letters, they're going to do it. So join in today. Get into the industry. Get involved and send those letters out. And number two thing that we can do, we have a proposal coming up, Prop 21, coming up here, not too many weeks away. Now, we put a bumper sticker in your AOA magazine. Now, there's a bumper sticker in there, and you say, well, there wasn't one in mine. I shook my magazine, and that bumper sticker didn't come out. And that's true. The bumper sticker will stick in there. You need to go through the pages of the magazine looking for the bumper sticker. And if you go through, oh, there it is. All of a sudden, you'll find the bumper sticker, and now it'll come out into your hand. So be sure to look through the magazine, read all the articles that are in there. There's also an article there coming from the law firm that's speaking today, that our speaker is representing today. So be sure to use that bumper sticker. Say, Dan, I can't put a bumper sticker on my car. You know, somebody will egg my car. No, this bumper sticker is really very friendly bumper sticker. In fact, the tenants see it. Here, I lost it myself. So that shows you how you have to look for that. And it says on there, vote no on Prop 21 to save affordable housing. Now, every one of those egg-throwing guys want to save affordable housing. So I think you can put this on your car with be pretty safe with that bumper sticker. Now, if you need more bumper stickers, or you didn't get one in the magazine, for some reason you can't find it in the magazine, just as I almost couldn't find it then, you can call in to get copies of it. Call in to 800-827-4262. It's up on the screen there. 800-827-4262. Leave your mailing address. Leave your mailing address. Maybe you have two cars. You want to put one on each car. Okay? And we'll have bumper stickers. We have a lot of extra ones until we run out. But leave your mailing address and your name on there, and we can send one to you if you didn't get a bumper sticker. Number two, you want to post the yard signs. The yard signs are not printed up yet, but they're being printed right now, and they're being mailed to all of you who have made a donation to the AOA Political Action Committee sometime within the last 2 years. And if you have done that, you'll receive it in the mail unless you gave your post office box mailing. They won't deliver these signs to the post office, and so you'll want to call in and make sure that we have your mailing address so that it'll go to your home or your business delivered to you, so you can put it up in the yard or in front of an apartment building. So that's the post signs being put up. Be sure to get those put up. It'll be about 3 to 4 weeks before we get those signs to be delivered, and so don't get anxious if you don't have it tomorrow. It'll be some time now. Now, these things cost money, of course, and people call and say, what is AOA doing? AOA is very involved in this fight against 21. As you can see, we have the bumper stickers, we have the yard signs, the mailings that we're doing. Goodness, today we sent out a mailer we sent out to the governor. We sent about 1,692 notes that you have written on the petition. We sent that in a pile in a big envelope to the governor's office. We also sent him the 88,000 signatures that we've been able to gather on the petition. And so those are things that need to be paid for. There's lawsuits coming up that are going to need to be paid for. The mailings that we do, the TV and other promotions as we join together with other groups against this Prop 21. Now, why do you want to beat Prop 21? One good reason: they're going to take away vacancy decontrol. So if you have some low-paying renters in there, they're paying $1,000 a month for a $1,500 a month apartment, you're not going to be able to raise it up to that if this proposition passes. And you can stop it from passing. You want to vote. You want to put up signs in your yard. You want to put a sign on your car. You want to donate to the AOA Political Action Committee to pay for even more activities to stop this program. Go to the AOAUSA.com/PAC. Should be on the screen there. AOAUSA.com/PAC, or send it to the 6445 Sepulveda Boulevard address. or the local offices that you have, like in Alameda up in Northern California, San Diego office, the Long Beach office. You can also send your contributions, your donations to the Political Action Committee to those. I want to thank you for being on the program today, and I'm going to almost guarantee that you're going to get a good idea that'll help you make and or keep more money than ever before. And I'm going to ask Jeff Fowler to come up, and he's going to be introducing our next speaker. Thank you for being here today, and send in those donations, and let's join together and beat this Proposition 21. Thank you very much.
All right, well, I hope you're a little encouraged. I know it's very discouraging when you think of all the political things that are going on, everything that's against us, but we're here for you, and if we all band together, there's a whole lot more that we can do. So there's so much to say for hope, and hope that you're able to get involved. I have a little more good news for you. If you have never, ever been a member of AOA, we have an opportunity and we would like to give you a 6-month free membership. And so that's if it's your first time, so it's first-time customers only, but you're able to go online and you can sign up online, you can call in, and so we want to make that available for you specifically, and also just want to give a few updates and tell you about the association. And so first and foremost, we have our advisors. You can call in 8:30 to 5, and they'll be able to answer questions for you that you might have related to landlord and tenant law. We also have, as Dan mentioned, the local offices, and they're there. Right now, we're not taking people in the offices because of COVID, but they're there for you. And we have the forms, and we're always updating those, and they are current, and they are for you to use as an AOA member. And we have the AOA tenant screening, and this has been a service that's been around since the 90s, and it's been developed, and we have the right mix, we've partnered with the right people to give you what we believe is the most reliable report out there. And we have the magazine, as Dan shared about. There's the Money Saver coupons on the back page, and everybody in there that's advertising is open for business. And so our vendors, they wanted you to know that. I did want to give an update on debt reporting. You may report debtors now, and as long as they have moved out, from what we're hearing from our legal counsel, as long as they move out, you're able to report their debt through our debt reporting service, and their debt will appear on the top 3 credit bureaus. So TransUnion, Equifax, and Experian, they're going to get that, and that's going to show up on their record. And that's one way to hold them accountable. That's one way to help the next guy when he's looking at the credit. They need to be able to see that so that they can understand who they're dealing with. And so, yeah, it will be case by case on the COVID hardship. If they were sick with COVID or are sick with COVID, that might be it's going to be case by case. So that's an update on that. Our brokerage, yes, we have a brokerage, and we offer free property valuation for those of you that are interested in selling your property. And those guys have been in business for a long time, and they will help you. And we have a couple partnerships, one with Livable, which is a smart utility billing service, and it's enterprise level, but it's for people, it's for owners that are either large or small, and that's why we partnered with them, because we know that most of you don't have 100 units, don't have 50 units, and so that's fine, they can help you. And we also have a partnership, a specific apartment-specific insurance, and so you can call us here in the office and we'll be able to transfer you to them. And there's Pay Rent, which is a rental payment platform that we have. And so there's lots of different things, and there's more things coming in the near future, so we're excited to continue to add to our services and offerings for you. And also, before we get started, I want you to know that this is a live stream, and we will be taking questions at the end. So you can submit your questions if you're looking at this live stream from the AOA webpage. You'll see it at the bottom right-hand corner. There's a little help button. If you click on that, you'll be able to type in your question, and hopefully we can get to that question for you. Well, today, now it's time to get started. So today, I get to introduce our speaker. He's been in the business for 44 years. He has 12 attorneys working for him full time right now, and that's a little bit lower than normal because they're not doing as many evictions, as you know. But he's going to answer some of these questions, like when can you start evicting people? And he has done over 200,000 evictions. I don't believe there's anybody in the country that's done more than him, and tremendous experiences. And he has even evicted boats, and quite frequently actually, boats out of harbors, and even an airplane from an airplane hangar. And so he has all kinds of experiences, and he's ready to share with us what his expertise. So it's my honor and privilege to introduce to you Dennis Block. Thank you.
Thank you, Jeff and Dan, and welcome everybody to this wonderful webinar that the AOA puts on. The Apartment Owners Association is the premier apartment association in the state of California. I've certainly been a member for the last close to 35, 40 years, and I do encourage everybody to join and take care and use the services that they give. Well, Dan was talking a lot of doom and gloom about our industry. And the truth is, Dan, you're right. Our industry is facing a crisis that I have not seen in the last 44 years. As Jeff was saying, if you do have questions, you'll be able to write those questions down on the website where you are now, and I'm going to attempt to answer most of them at the end. But I want to go over what's happening to us as an industry now, what challenges we face. Is there any hope on the horizon? And probably not. But we still have to be diligent in terms of what our rights are and how we can take advantage of the situation. Our politicians right now think that it's a proper idea to punish income property owners on the basis that there's a pandemic. I mean, that's basically what it is that the financial burdens of the pandemic should be placed right on the shoulders of income property owners. No other industry has to support another segment of society except for landlords. And that's really where we are right now, that landlords are facing what they call rent deferment up to 1 year. Really, it's a joke because no one's going to get paid their rent after 1 year. These tenants are going to go away, so they might as well have called it rent forgiveness. They can't use that term because, quite frankly, it's unconstitutional, but they did the next best thing. They gave it a label called rent deferment for 1 year, and on that basis, really what they're doing is taking away all of our rental income. And how landlords are going to survive in this period of time, God only knows. As Dan stated, many tenants who aren't working, and most of them are. I mean, 90% of our country is employed. 10%'s not. Of the 10% that's not, most of them are getting unemployment, and a lot of them are actually getting more money than what they were making on their job. So to sit there and call out one segment of society, income property owners, and putting the financial burdens of the pandemic on them is clearly against the fabric of our society. Let's go over now what the laws are, how they're affecting us. Every day I sit at the office and we answer questions. By the way, my office number is 1-800-77-EVICT. If you do have any follow-up questions, 1-800-77-EVICT. My website is evict123.com. But all day long we're answering questions. And I'll tell you something, we're getting the same question over and over and over again. And the question is, well, when can I start an eviction? I have a guy who's not paid rent for the last 6 months. So when can I finally get my place back and at least attempt to rent it to somebody who's willing to pay me the rent? And it's a very complicated question. I hear clients telling me, well, I'm free to do it as of September 1st. I'm free to do it as of September 30th. You get all these dates from clients, everyone here. Well, I just heard that on the news, September 1st. We can go forward with this. All of those are correct, but you see what's happened is that the laws have been generated that are so confusing and so broad that everybody's correct and no one's correct. So let's go over with this and we'll try to put some sensibility to this so that you guys understand that that person who hasn't paid rent in 4 or 5, 6 months, what are his obligations and what are your rights in that situation? The problem is that we really have to conform not just to Governor Newsom's orders, we also have to conform with the Judicial Council for the state of California. We also have to conform with the local county where your property is located in. And then let's just wrap it up, and you also have to comply with your local jurisdiction, the city where your property is located in. All 4 of them could have competing ordinances, and guess what? Your job? Comply with them all. So while you're hearing certain things about September 1st and certain things about September 30th, and then maybe April, everybody's correct. So let's go over the confusion and let's put some sensibility to this. Not that we're going to like the answers, but at least we'll know what's going on. So Governor Newsom originally, when he made his first orders back in March, stated that there would be no evictions through June 30th. After June 30th, from his standpoint, you could do whatever you want. Well, the last time I checked, we're in the month of August, so of course, we're free to do evictions. But the answer is no, we're not. He also gave an additional order, and that's the one that's kind of hard to conceive. This additional order states that he's giving the rights to local municipalities to create their own eviction moratorium. So it's not exactly the state that's stopping you from doing the eviction. It's the giving of the right by our governor to different municipalities to create their own eviction moratorium. Now, he had one cutoff date, and then he expanded it. Currently, that cutoff date is September 30th. September 30th, 2020. And that gives the right for these municipalities and counties to create their own eviction protection. So, for example, let's take the city of Los Angeles. Basically, they're all the same from all these jurisdictions. But let's take the city of Los Angeles. If a tenant doesn't have the ability to pay the rent and it's causally connected to the pandemic, then his rent is deferred. This is the city of Los Angeles. And it's deferred until the pandemic is declared over plus 1 year. Plus 1 year. And again, as I started out, who's going to be chasing their tenant after that 1 year? Number one, if the tenant's not at your property anymore, are you going to be doing skip tracing to find out where he is and to bring forth a lawsuit? The answer is no. So in most situations, what we're talking about is rent forgiveness. It's going to be free rent. So when is the pandemic going to be over? Well, according to the governor, it can't go longer than September 30th. So right now in the city of Los Angeles and up and down the cities in the state of California who have adopted this, you can't ask that tenant to pay the rent. You can't serve a 3-day notice through September 30th. Now, after September 30th, October 1st, assuming it doesn't change, and we're praying that it doesn't, then the landlord will be able to demand that tenant who hasn't paid rent since March of 2020, on October 1st, you can demand the rent, but not rent through September 30th, not for the March, April, May, June, July, August, and September. You can demand October's rent. And if they do not pay you October's rent, then you have the right to serve a 3-day notice and proceed forward with an eviction at that point. Now, when is that rent going to be owed to you? The rent that they haven't paid from March, presumably to the end of September, that would be October 1st, 2021, 1 year later. Some jurisdictions have a 6-month period for residential property. Most of them have a 1-year time period of deferment. Now, people sometimes have the impression that, well, that means that during that 1-year period, the tenant at least has to pay like 1/12 of the rent for each month, at least of what's owed. And the answer is no, they don't. Or they can wait until the last day, and which would be October 1st, 2021, and that's when the rent would be owed. But remember the way all these statutes are written, that the tenant didn't pay you the rent due to the pandemic, that was causally collected with regard to the reason why the rent was withheld. So for example, a person who works at a salon, a hair salon, that person legitimately lost his job, he can't afford the rent. A person who works at a restaurant legitimately lost his job or his hours were cut down. These would all be true reasons why they would have an inability to pay the rent. You also have a situation where someone is out of work even before the pandemic, but of course their position, and maybe rightfully so, is that, hey, I can't get a job now even if I'm looking because of the pandemic. Or sometimes you'll have a situation where I didn't lose my job, but my kids couldn't go to school. So if my kids can't go to school, someone's got to watch them, and that's me, and therefore I had to leave my job. These are all legitimate reasons. Maybe you got the coronavirus, you had to stay home, or maybe a family member got it and you had to take care of them. This is what these local municipalities envisioned when they wrote this law of an inability to pay. But of course you have wholesale situations where people are obviously taking advantage of the situation. We have situations where rent wasn't paid, for example, for November, December, January, February, and of course from March forward in time. Now I would submit to you that for those months, anywhere from November through February, those months have nothing to do with the pandemic. We have filed many lawsuits, I might add, on those cases because it's not an inability to pay the rent. But by the way, you better be sure if you do file the lawsuit that the tenant doesn't have that excuse. Because if he has that excuse, then technically they could bring a civil action against you in the city of Los Angeles, in Culver City, in Beverly Hills, certainly, and also in Northern California as well. They can bring a lawsuit. So you don't want to be filing notices and starting evictions if in fact it is causally created to that pandemic. However, there are so many abuse cases that I have seen where someone, for example, is on a pension. You're on a pension. They didn't lose their job. They're not financially affected whatsoever. In that situation, we could file that lawsuit, and of course we have. Or, for example, we have a case where a person was paying rent on a house in the hills of Hollywood. The rent per month, $55,000 per month. And the person decided that he was going to stop paying rent. And was his livelihood affected? And the answer is yes. He dealt with exotic cars. I'm still dealing with this lawsuit. He dealt with exotic cars, rentals, and of course that business has fallen off. So he truly lost his income. But what he doesn't tell anybody is that In January, when he was being qualified, January of this year, he had $4 million in a bank account. $4 million in a bank account. And based on that, he certainly has the ability to pay the rent. I've had tenants come up to landlords and say, hey, you know, I have the money, but I'd rather preserve my own capital. I have the money, but I'd rather preserve my own capital. So these are people that have the ability to pay the rent. Now, according to these local jurisdictions, I have the right to go forward with this lawsuit. And so we have. We have gone forward with these lawsuits. A lot of times the lawsuits have nothing to do with rent. Maybe they brought in extra people. Maybe they brought in dogs that they shouldn't have. Maybe they made alterations to the premises. All these are cases that we have brought forth, and we have case numbers, and they have been filed. But you see, we have to deal now with another entity. And the other entity is the Judicial Council for the state of California. The Judicial Council is an administrative body that is sanctioned by the Constitution of the state of California. It's set to be for the efficient running of our court systems. That is, when are courts opened and closed, what judges are going to sit in what courtrooms, what cases are going to be heard in this court versus another court. It's for the efficient running of the court system. They also approve all the court forms. If you've ever seen a lawsuit, look at the bottom of the lawsuit, and it says approved by the Judicial Council. So what did the Judicial Council do? The Judicial Council on April 6th, 2020, created emergency rules. These emergency rules, and remember, we have to deal with all these different entities. And everyone has their own rules, and that's why you're hearing all these different dates. So let's go over the Judicial Council. They created emergency rules that stated, with regard to the filing of an eviction or the continuation of an eviction, that you can't do it, period. It stopped all evictions, regardless of the reason, regardless if the person had the ability to pay the rent, regardless if it had nothing to do with the coronavirus. The Judicial Council, in their emergency rules, stated that you can't get a summons. I can file a lawsuit, I can get a case number, but I can't get a summons, which means I can't serve the tenant, which means that I can't go forward with the lawsuit. It also stated that for those lawsuits, for example, I have so many lawsuits that were filed and I had a summons issued, and I had already served the tenant, and now my next step is to take a default. The Judicial Council says you can't take defaults, even though that's a particular code section in our civil code, which states exactly that we are allowed to. The Judicial Council decided that they would create their own rules to basically stop all eviction cases, regardless of the reason. Now, happy to tell you, the only horizon that is silver, that what the Judicial Council did was illegal. It was unconstitutional. It's actually, in an offhanded remark by the Chief Justice for the California Supreme Court, acknowledged the fact that your Judicial Council did not have the right to create laws. And laws is what they created. The California codes specifically state that I get a summons in an unlawful detainer. It also states that I can file a default in an unlawful detainer. Those are civil codes. The Judicial Council wiped out those codes. Now, they don't have civics anymore in high school and middle school. I wish they did. But if for those people that did take civics, and we know a little bit how governments work, in the state of California, only two things can create laws. That is our governor during an emergency situation, such as a pandemic, or the California State Legislative Body. And of course, they have to pass it. The governor could veto a law, then they'd have to override the veto with a 2/3. But those are the only two bodies, our governor and the state legislatures, that can create law. Well, the Judicial Council, I don't know who they are, But they created their own laws, their own emergency rules, which stopped every unlawful detainer in the state of California from going forward, regardless of the reason, having nothing to do with the pandemic. And by the way, let's not lose sight of the fact that we certainly see a need for tenants. But why is a landlord put into a position, an income property owner put into a position where they have to be financially responsible for their tenants? As Dan was saying, if let the free market rule, let people figure out their own ways, or at the very minimum, if the government wants to be a safety net, then let them be a safety net. Let them give rent vouchers to landlords. Let them take care of it. But to put this on the backs of landlords is insane and is against the fabric of what our country is about, which is a free economy, which is why people came to this country. But in any event, our Judicial Council rewrote the laws without any legal authority. And then they had a sunset provision. That's when this would finally go away. And what was the sunset provision? When would their laws expire, their emergency rules? It would be once the pandemic was declared over, plus 3 months. Plus 3 months. So if the pandemic is going to be declared over, according to our governor, on October 1st, then it wouldn't be until January 1st that I could finally get a summons issued. And if we do the math, if you have a tenant who hasn't paid rent since March, April, May, June, July, August, that's 6 months. And now you're going to have at least another 4 more months. You're going to have 10 months before you can just start an eviction case. Just start an eviction case, which would start around January. And then how long is it going to take to go through an eviction when you have, quote, a flood of landlords filing evictions? Now, the biggest joke is the media. And the media says, oh my God, we're going to have a tidal wave of evictions. A tidal wave of evictions. Well, first of all, if you stop people from filing evictions, well, of course you're going to have many more people filing when you finally can. That's obviously logical. But what the media should be saying is that you're not going to have a tidal wave of evictions. What you're going to have is a tidal wave of foreclosures. Because how are landlords going to be able to lose revenue for over 1 year? How is that going to happen? And when landlords lose revenue for over 1 year, is there any forgiveness for mortgage payments? Maybe a little, but they're still going to have to pay it. Do they have to pay their property taxes? Of course. If the tenant is complaining about something in his unit, does the landlord have a legal obligation to take care of it even though no rent is paid? And what about water and sewage charges? Does the landlord still have to do that? Of course there's going to be a tidal wave, but Mr. Media, the tidal wave is going to be a tidal wave of foreclosures for income property owners who are forced into a position of having to support a different segment of society. And no other industry is put into that position except income property owners. So let's go back to the Judicial Council. What they did was illegal. My law firm filed suit against the Judicial Council. That suit made its way, and it's sitting right now at the California Supreme Court, and we're waiting for a ruling. Our case basically, and I want to thank anybody who did donate to our cause, but it's sitting right now for a judicial ruling by the California Supreme Court. And it based itself mostly on the issue that the Judicial Council, this administrative body, didn't have the right to create laws. And so they didn't. And this was even backed up by, I mentioned, the Chief Justice for the California Supreme Court. So what did they do? Well, I'm going to contend that I am victorious in my lawsuit, even though it hasn't been fully decided by the California Supreme Court. I'm going to declare victory because the Judicial Council met, and here we get to that other date, and states that they're revoking their emergency rules. Really? You're going to revoke a rule that you didn't have the right to take in the first place, but they're revoking it as of September 1. September 1. So if we take a look at a calendar, I only got a couple of 3 more days. And what that means is any lawsuit that's already been filed that was not based on the pandemic, I will now be able to get a summons issued on that case. And I will be able to serve that tenant, and I'll be able to go forward with an eviction. Anybody who I've already had a summons issued, I've already served the tenant, those cases that I've already filed, and we have filed hundreds of them, those cases I will now be able to take a default, get a writ issued, and deliver to the sheriff's office. The sheriff's office now is just starting to institute finally lockouts where people will finally be able to get back the property that, call me silly, that they own and they haven't received rents on for 6 months. So I think it was part of the pressure of the lawsuit, of my lawsuit, I know there was another one as well, that put light on the subject that the emergency rules, which stopped every eviction in the state of California from going forward, now we can go forward. But here's the rub, okay? If you have a tenant, this is what I want to go back, because we've got to interpose the laws dealing with local municipalities and also the governor's law, and also where we are now that the Judicial Council emergency rules are expiring. We have to go back and think this out. If I have a tenant and they didn't pay April, May, and June's rent, legitimately because of the pandemic, I still can't serve a 3-day notice, even though the Judicial Council rules don't exist anymore, because I have to deal with the local rule. And the local rule says if the tenant has an inability to pay due to the coronavirus, then the landlord cannot serve a 3-day notice, and they can't give that notice over to the law firm of Dennis Block to file an unlawful detainer. So if we have all those cases where, for example, rent was not paid prior to March 1st, those cases we can start right now or already have started. Those cases not dealing with the pandemic, for example, unauthorized persons, animals that they shouldn't have, or people who do have the ability to pay the rent. Those cases, whether they've been filed or not filed, those cases can now proceed as of October 1st. And boy, are we geared up to start going forward with these cases. A lot of pent-up emotions here. But we can go forward. But I want to counsel everybody that if your tenant is claiming that they have an inability, you're still in the same situation whether we have those emergency rules or not. You now have to deal with the rules dealing with your local municipality. Now, for example, and you have to check the laws for where your property is located, and we're happy to do that for you. I'm always getting online every time someone calls, Pico Rivera. You know, you name a city and we have to, of course, look it up because we don't have all the cities and what their local rules are. But in Los Angeles County, there's an interesting thing. You have many cities that have their own local jurisdictions and their own rules dealing with the eviction moratorium. But in Los Angeles County, for example, the county of LA said, well, if a local city doesn't have rules, then it falls under our jurisdiction. So for example, if you have a jurisdiction, let's take Southgate, which doesn't have an eviction moratorium, well, based on the Judicial Council, I could go forward with that. I could serve a 3-day notice, I can go forward with that. But the problem is that Southgate and all those other cities, Redondo Beach and any other city you can think of, now falls under the county. And the county says if you have an inability to pay rent, then you're deferred for 1 year from when the pandemic is over. So it's tricky to understand and interpose all these rules together. But once again, if you have a situation where your tenant has the ability to pay the rent, or it's not involving a rent case, those cases are now freed up to go forward with it as of October 1st. And I'm encouraging people, get in while you can, because we don't know what the state legislature and our wonderful governor is going to be doing in the future. Now, tenants, for example, like in the Los Angeles area, but this is also all up and down the coast, or in LA County, the landlord's going to state, well, I'm not so sure that he lost his job. I think he's working. So in order for me to know whether he has an inability to pay rent due to the pandemic, I should be able to ask for some proof. That's reasonable. Well, no, it's not. In the county of Los Angeles and in Los Angeles and a bunch of other municipalities, no proof required. So all the tenant has to do is say the magic words. And what are those magic words? All the tenant has to do is, I can't pay pandemic. I can't pay coronavirus. I can't pay COVID-19. You say those three magic words, your rent's deferred for up to 1 year based on our wonderful mayors of all these cities and our supervisors of our counties. So that's where we stand now, where, remember, we have to interplay all these dates. So what's the September 1st date? To recap, the September 1st date is where the Judicial Council's rules will expire. So now any case we can go forward with. Then we have the governor, who's talking about a date called September 30th. That's where he gave municipalities the power to create their own eviction moratorium. So if that stays in place, that's why I'm saying a landlord would be able to ask just for the October 1st rent, because the municipality doesn't have the right to extend it past September 30th, but as to all rent owed up to September 30th, then that would be deferred based on what that municipality states, 1 year, 6 months, whatever the particular municipality states. But most of them are 1 year. And literally we're going to see, again, a tidal wave of foreclosures that are befalling landlords based on the stroke of a pen by our elected officials. If anybody does need to have any further questions, we're going to start taking them now. I'm sure there's a bunch, and again, you can always call my office at 1-800-77-EVICT. I'm sure my associates will love the fact that I'm plugging that. Or you can go to my website for additional information at evict123.com. But I think we got Jeff's manning the question lines here. And if you want to tell me the first question, let's see if I can answer it.
Okay, here we go. We have one from Frederick. And here's the question. Does the current laws in place impact a condo rental if the intent is to put the unit on the market for sale? May I serve a 60 days notice to vacate?
The answer is it depends on the local jurisdiction. Did everybody hear the question, or do you want me to repeat it?
Should I repeat it? Okay, I'm sorry. Let me repeat that question. This is from Frederick, and here's the question. Does the current laws in place impact a condo rental if the intent is to put the unit on the market for sale? May I serve a 60 days notice to vacate?
And the answer to that is it depends. I wish Frederick had stated what city his property is located in, because it goes with what the Judicial Council, with what the local municipality has instituted. So let's take, for example, a condo in Orange County. In most jurisdictions in Orange County, there are no more eviction moratoriums from most cities. There's a scattered few. So a condo generally is not under any rent control. So a condo in Orange County, you would be able to serve a 60-day notice, assuming the tenant has been there longer than 1 year, and proceed forward with an eviction right now. Of course, the Judicial Council is up as of September 1. But let's take, for example, Los Angeles City. Los Angeles City states there can be no-fault evictions. So whether it's a condo or a single-family home, you can't serve a notice to quit. But what if that owner has his property in escrow to be sold? And he served on that tenant a 60-day notice to vacate. The tenant's on a month-to-month tenancy. And the sale has to close. What happens then? And the answer is, our mayor, Garcetti, doesn't care about you, doesn't care about the homeowner, because you see, the way it's written is that you can't do any no-fault eviction. I just can't ask a tenant to move unless the tenant's done something wrong. And then, of course, there's a lot of limitations to that. So for brokers out there, all those sales, they're just going down. Nothing's going to happen because you can't get the tenant out. And if that was a condition of the escrow, and even though a proper 60-day notice was served in accordance with California law, the tenant was only on a month-to-month tenancy, during this period of time, I can't serve a notice to quit. I'm going to have to wait for the pandemic to be declared over, which means that I would first serve a notice as it is currently, as of the taping of this broadcast, as of October 1st. October 1st, I could then serve a 60-day notice. And if the sale is lost, politicians just don't care. Next question.
All right. This is from Ming Ming Chen in where is she? Yeah, from Los Altos. And she's asked questions before, so it's good to have you with us. And here's her question. Since that the state and county since what they're doing is unconstitutional, can we landlords sue these politicians? I'd like to find a good lawyer or law office to sue these politicians. Do you have any recommendations? Does your law office do this kind of lawsuit?
My law office doesn't do that type of lawsuits. There's been class actions filed, I know already. I know in the city of Los Angeles, suing Mayor Garcetti and suing the city council for what we call a taking, an unconstitutional taking, because we know that that's what this is going to be, that landlords are just going to be losing rent left and right. And by the way, as we speak, we know that the vacancy factor for landlords are on an extreme rise right now. So not only are landlords having an inability to lease property, as to the property that is leased, they're not getting their income. I believe lawsuits should be filed. I know there are some jurisdictions where they already are being filed, and someone just do a Google search and you'll be able to join those lawsuits.
Okay, so Google search, there we go. All right. Okay, Christy Liu, and she's viewing from YouTube here. And it says the tenant's lease started 9/1/2019 on a month-to-month lease in San Gabriel. Oh, everything moved on me. We want the tenants to move. Can we still give a 30-day notice to quit under this eviction ban?
Okay, San Gabriel, the city of, does not have an eviction moratorium. So you would think you'd be able to do it, but San Gabriel is located in the county of Los Angeles. So since the city of San Gabriel doesn't have an eviction moratorium, it falls back to the county. And the county of Los Angeles, through their county board of supervisors, state that there can be no fault evictions, which means, to that question, you cannot serve a 30-day notice to vacate to those tenants. You're going to have to again wait till, as it stands right now, October 1st, before we can proceed forward with that.
All right, thank you. And we have, from YouTube, we have Jose Tejada, and here's his question. Is there any COVID-19 incentive for rental property owners? Maybe, does that
Not
make
sure
sense?
I understand that question.
Maybe he's talking about, is there any relief or any financial help out there for
I don't believe that there's any help for landlords. I know the city of Los Angeles, on a very small project, was giving the right for tenants to apply for a $2,000 voucher to landlords. They had very little money in the coffers, but they did allow tenants to apply for that, so that $2,000 could swing over to the landlord in payment of the rent. But what they didn't tell you in the fine print is that if you accepted the rent money from the city, then it was you were agreeing not to file an eviction for 6 months. So the tenant could basically pay maybe a month or a month and a half worth of rent at most, and then stop paying for the next 6 months, and you'd be restrained from filing an eviction. Made absolutely no sense. It also stated that you couldn't raise the rent for an entire year if you took this rent. So it was kind of like fool's gold that if you accepted this. So no, there's no hope for landlords. I mean, you just have to go out and see the way the landlords are portrayed in our media, and how evil we are by our politicians. There's no hope for us, and that's why these lawsuits. I wish them all the luck to go back and take care of what they've done, which truly is improper.
Right, thank you. And from the AOA website, we have Ivazi, and this is in Los Angeles, and they're curious if they can file a civil lawsuit against a guarantor for past due rents.
And that's a good question, because in one of the earlier seminars that I gave for the AOA, I was suggesting briefly that we should file a small claims court lawsuit. I'm not filing an eviction. Nothing stops me from doing that. But based on the clarification of the law, you can't do that. So let's explain why. You have a lease which says that tenant A is supposed to pay $2,000 a month, and he's not paying it. You have a guarantor that says, hey, Mr. Guarantor, I agree that if the tenant breaches his lease, that I'm now guaranteeing the performance of that lease. That's what a guarantor does. But you see, what we'd have to understand is that the local municipality rewrote your contract. So while your contract says, hey, I get $2,000 on the first of every month, your contract got rewritten by the local municipality. So what did the contract say? The contract now says, yes, you have to pay $2,000 a month on the first of every month, unless you're affected by the coronavirus. If you're affected by the coronavirus, then your rent is deferred for 1 year from when the pandemic is over. So the issue is, if the tenant doesn't pay the rent, have they breached their contract? And the answer is no, because their rent's not due now. It's due October 1st, 2021 at best. So the guarantor is in a situation where, yes, if the tenant breaches the contract, I guarantee its performance. But the tenant didn't breach his contract, and the reason why is that municipality took your contract and added an addendum to every single contract in the state of California, giving them eviction protection.
Great. Here's an interesting question. It comes from Northern California, and Allison. And what would you tell the owner when the county is paying the rent, but they're always late with the rent? How can you hold the owner, the tenant responsible when they can't control when the county sends them the payment?
Not sure I understand the question. I'm almost guessing that this is like a Section 8 tenancy, where the county would be paying a portion of the rent. I've never heard a situation where the county isn't stepping up unless there's some sort of a legal snafu with the paperwork in that individual's situation. But on Section 8, the landlords are getting their rent from the county or from the local municipality, but in many cases the tenant's not even paying their reduced share.
Yeah, it sounds like the county is just late here, and yeah,
I think that's more of an individual situation.
Mm-hmm. Great. And here we have from on YouTube, Bianca Fuentes, and she's coming from Riverside County. May we serve a 60-day notice to vacate in the meantime while we wait to file UDs in January?
And the answer is, you've got much better options. Right now in Riverside, we're good to go. You can serve a 3-day notice for all the rent. There is no delay. All the rent that's owed from March, April, and we can file the eviction lawsuit. And as of the 1st, I'll be able to get a summons. So for those counties of Orange, Riverside, and San Bernardino, and maybe a bunch others, because I don't have them all, in front of me here, and that's why it's not a bad idea to call the office. We can go forward with that. The only reason why those cases couldn't proceed, because we could have proceeded with those cases as of July 1st, because the governor's order only extended through June 30th, if you remember that part of this discussion, was because of the illegal actions of the Judicial Council creating those emergency rules. So that's why courts wouldn't issue a summons, so we were basically stuck in quicksand. So I am so happy that as of September 2nd, we'll now be able to apply for a summons and proceed with these cases.
Okay, great. And here's Drew from Orange County. Let's see. Did I do that one already?
Jeff, a little louder.
Okay, here we go. Yeah, Drew from Orange County is writing in Orange County, can we proceed with evictions after September 30th if the owner wants to sell and they haven't paid since January 2020?
Okay, clearly the rent owed from January and February had nothing to do with any pandemic. In Orange County, as I stated, we're allowed to go right now, this minute, serve them with a 3-day notice for the rent from January through the end of August and proceed forward with an eviction. And as of September 2nd, I'll be able to get a summons and proceed forward with it.
Okay, and thank you. Here we are, and here's from the AOA website. We have Sophie in Los Angeles, and she's asking, how can I evict a person who is not in the agreement but has taken over the unit?
Okay, well, a lot of times what you have is you rent to tenant A, they signed a rental agreement. Somewhere along the way, B moves in. Maybe the landlord knew it, maybe the landlord didn't know it, and then A moves out. I'm guessing that that's what the situation is. As long as the landlord hasn't taken rent from B, that's an eviction that can be started in any location right now. It's an unauthorized subtenant in possession at the end of the lease term. So based on that, that would be a case that we could start right now.
Okay, great. And then we have a YouTube viewer, Deanna Cho. If a city within the within the County of Los Angeles passed a moratorium that has now expired, for example, Inglewood's moratorium expired on June 30, does the County of Los Angeles' moratorium now apply to that city?
And the answer is yes. That was the insidious part of those pesky county supervisors. So if the municipality had its own eviction moratorium rules, but let's pretend they expire July 1st, that's now picked up by the county. So, and that's why these laws are all so confusing and why I'm getting question after question at the office as to whether we can go and June 30th and the date of September 1 and the date of September 30th, because these laws are insidious and really they all have to be studied as to your specific property. But to answer that question, when Inglewood's eviction moratorium elapsed, then it was picked up by the county, which means you can't demand rent through September 30th if it's related to the pandemic.
Okay, great. And here's a good question from Scott McNeely on YouTube. And it's related to, hold on, I had it up, here we go. Is the state pursuing any actions that would support mortgage deferments for landlords based on tenants' COVID claim of inability to pay rent?
Well, the state is certainly encouraging financial institutions to give some sort of a relief to property owners, but that's all they can do. They can encourage, and it's kind of half-hearted attempt on their part. If they wanted to do something, they should just step up and pay the rent to these landlords. But don't forget, a financial institution, if they're going to defer mortgage payments, let's say without even a penalty. So this person who's having to pay his mortgage payment, and of course he's severely strapped on the basis that there's no rent coming in with the approval of our elected officials, what is this financial institution going to do? And let's say they want to give relief. So what relief are they giving? Typical relief is no penalty, and I'll give you 3 additional months to pay me. But what does that do? Number one, rents aren't coming in for up to 1 year, 6 months to 1 year. And then at the end of the third month period, guess what? They're going to owe 4 months worth of mortgage payments. Where's the landlord going to get it? It doesn't make any sense to even take the deferment at this point. All it's going to do is to stave off the inevitable foreclosure. Yes, the tidal wave of foreclosures, not the tidal wave of evictions.
Wow. Okay, here we have YouTube with Sergio. I have a tenant holding 2 one-bedroom units and hasn't paid on either of them for 5 months. No COVID issues, just choosing not to pay. It's in Compton, and there's no local ordinance that he's aware of. Would we go by the state law?
That would go under, again, the County of Los Angeles, because Compton doesn't have its own eviction moratorium. So it goes under the county. And the county, as they all do, say if the tenant has an inability to pay due to the pandemic, if the landlord can establish that the person who's taking both of those units doesn't have an inability to pay, those lawsuits can be started right today. Right today, I would be serving a 3-day notice, and I'd be filing that lawsuit, getting a summons issued as of September 1, and I'd have that tenant served immediately.
Great. Yeah, we have a question from George here. Real good question. At what point can we start sending people to collections? And he specifically, he's got $20,000 in bad debt already.
There are so many landlords, and I hear these stories, and it's so heartbreaking, of that this tenant owes me $15,000, this tenant owes me $20,000, this tenant owes me $10,000. These debts are just astronomical of the amount of money landlords have lost. Not big landlords, not that it makes any difference, by the way. I always chuckle when they say, well, we're just small mom and pops. My heart goes out to small mom and pops, but the fabric of our country is for the big landowners, the big corporations. Why do they have to be thrown under the bus? Everybody's entitled to make their profit in this country. But in that situation, they have a right to collect the rent, and there are so many persons that are owed so much money under this situation.
Okay, great. And we have from the AOA website, they have a tenant that's just been a single family. They've just been a total headache even from before COVID-19, and they're wondering if they can evict them for nuisance.
Well, you can evict the tenant even under any circumstances, even under the Judicial Council rules, if it's dealing with health and safety. But what lay people who are not attorneys, think a nuisance is, generally it's not. There really has to be some serious conduct dealing with safety, you know, that he threatened someone's life, took a gun out, did something of a major faction, and then we could start that lawsuit. But there is hope on the horizon that if the pandemic is declared over as of as of September 30th, then on October 1st, the landlord can proudly serve that tenant with a 60-day notice to vacate, assuming they've been there longer than 1 year.
And on that, what do you generally need documentation-wise or evidence-wise to be able to be successful with a nuisance eviction?
You're going to have witnesses that will step forward and say, this guy threatened my life. This guy took a rock and hit me. I've got one where I've got videotape of literally a tenant taking his car in the parking lot and speeding it towards the resident. I mean, speeding it towards the landlord. So, and it's funny, in that case, we got a letter from an attorney saying he didn't do this. We got the videotape, and he's imploring us not to go forward, even though the videotape clearly shows that the landlord had to literally jump out of the way of this car that was speeding towards him.
Wow, okay. And then we have one here. It's JJ on YouTube, and his question, his units are in Santee, which is part of San Diego County, and he gets partial rent payment from his tenant, but does that impede his ability to evict later for non-payment of the unpaid portion once the moratorium is
Right.
lifted.
I would have to look that one up, but my belief is that he could start that case right now, that there is nothing in that area of San Diego County which would prevent a 3-day notice from being served for the balance owed and proceeding forward with a lawsuit. Again, we couldn't proceed forward with a lawsuit because they were based on the illegal orders of the Judicial Council, but as of, thank God, after September 1st, the handcuffs have come off and we're ready to rock and roll.
Okay. Thank you. And man, we got lots of questions coming in. I hope you have a lot of extra time here.
Oh, let's do it for like another 15, 20 minutes.
Okay, great. And from the AOA website, we have Anna and Van Nuys. When can I raise my rents if I'm under the LA RSO?
And the answer to that question is the wonderful City Council of Los Angeles has stated that no rent increases for 1 year. So that means as of October 1st in the year 2021.
All right. Okay. And then we have Bob in Los Angeles. Dennis, you mentioned that an eviction cannot begin until the emergency order is lifted plus 3 months. What city or situation is this for?
Okay, again, that was the Judicial Council's emergency rules that they promulgated on April 6, 2020. They have now since revised that order, and that is now over as of September 1st, 2020, so just in a couple of days. So those lawsuits can now all proceed.
All right, we have Hector on YouTube here, and he has COVID-19 tenant qualify for moratorium. Okay. Here we go, one more time. Hector is asking about a COVID-19 tenant qualify for moratorium until October 1st. Can they be evicted for health and hazard conditions assessed by Health and Housing Department?
Yes, if it's a health and safety issue, then the landlord can commence an eviction right now. Again, we have to determine whether in fact what the tenant is doing actually qualifies, but assuming that comes in, yes, we have the right to do so.
Okay, great. And then we have Jessica Garcia from Los Angeles. Can I serve a 30-day notice to someone who is renting out a room if I am on a month-to-month lease?
So what we have here is a tenant who has subleased one of the rooms, and the issue is where that's located. If you're located in an area, a local jurisdiction which prohibits no-fault evictions, the answer is no. But if that property, for example, was in most places in San Diego, Orange County, and Riverside or San Bernardino, you could.
Yeah, so it would be for Los Angeles, and it's a single family home where she actually lives.
Okay, then in that situation, the answer is no. You can't, because that would come under the County of Los Angeles, and they have a prohibition against no-fault evictions.
Okay, great. And let's keep moving along here. Okay, this is from YouTube. And it's BLK Box LA. My name is Sergio. I have a tenant holding 2 one-bedroom. Oh wait, we did that one already. We answered a question just like that. Let me see if it's any different. Let me ask it just in case. It's got a little bit of a difference. I have a tenant holding 2 one-bedroom units and hasn't paid on either for 5 months. No, that's exactly the same question.
Yeah, I think we did that one.
Yeah, that's.
It was a good question, though.
Yeah, his name was on that one. I think he submitted it twice. Okay, and then we have Facebook with Christine Lequang, it sounds like. Excuse me if I didn't get your name right. Month to month here's the question. Month to month, Section 8 tenant in Northern California, Santa Clara County, not under rent control, has not paid rent June and July, did pay August. Section 8 will terminate contract and stop to pay rent on September 15th. No sign. Let's see. No sign of moving. if the tenant was to pay her September portion, not the Section 8 part of it, that's what she would like to do. Okay, I'm going to ask this question again because I think I probably lost you. The questions are moving here on the screen, and I'm having a little difficulty. So one more time. She's up in Santa Clara, Section 8 tenant. They didn't pay July and June and July. She paid August, and then the Section 8 is going to terminate on September 15th. No sign of the tenant moving. If the tenant was to pay her September portion, okay, she's curious. I would want, okay, the question's hard to read here. I want out of my property. Do I reject her September portion? What can I do to get her out?
Okay, well, you're going to, if she's under Section 8, if Section 8 is terminating her from the program,
right.
This is what they call a rent subsidy. That's what Section 8 does. They subsidize the rent. So if there is no subsidy, that means that the tenant is responsible for the full amount of rent. But you can't just, quote, terminate the tenancy. And I'm not sure of the eviction laws for that particular jurisdiction. If they don't have rent control and it's not subject to any eviction moratorium, then once Section 8 terminates, you could serve a 60-day notice to vacate at that point because she's no longer under the Section 8 program. So it would be a 60-day notice to terminate. But again, the fact that Section 8 terminates, that doesn't mean that the tenant has to leave. It just means that the tenant is responsible for the full portion of the rent.
There we go. Hope that answered your question. Here we go from Facebook. We have Saeed Afari. If you are renting a condo, do these laws apply to the landlord?
And the answer is that generally a condo is not subject to any rent limitations. You can raise the rent to whatever you like. If your condo is for example, in Los Angeles and was built prior to 1978, you're under the RSO, Rent Stabilization Ordinance, and you'd have to have good cause to evict. You still can raise the rent to whatever level you want, but you would need good cause to evict. So it really depends on the local jurisdiction. Now, if the local jurisdiction has an eviction moratorium, if that eviction moratorium prohibits no-fault evictions, like Los Angeles and LA County, then you can't serve a notice to quit. But if that jurisdiction, for example, let's take a place in Orange County, at that point we could serve one because there's no eviction moratorium with reference to no-fault evictions. A lot of the eviction moratorium, the local ones, only dealt with payment of rent. So in a lot of cases we were serving a notice to quit since that was our option to do so. That's also true in Los Angeles on commercial, which was also dealing with eviction moratoriums, but only as to rent. So we've terminated a lot of commercial businesses where they weren't paying rent without asking for that rent.
Okay. Yeah, and Dennis, I know, here's a question from Facebook. It's Charles Griffin. Dennis, I know that you're an apartment owner yourself. Are you renting out your vacant unit? When you get a vacancy right now, are you going ahead and renting those out, or are you waiting?
Well, I understand the intrepidation on the parts of landlords who have a vacant unit and they're thinking, listen, if I rent this out, he'll pay me the first month's rent, and then he'll stop paying, and then I'm going to have to go through an eviction. I can only tell those property owners that believe that I know for 100% accurate that if you don't rent it out, you will make no income. That I know 100%. You've got a chance that if you do rent it out and you screen well, certainly through the apartment association, that you will get your rent. I recommend getting at least a 2-month security, go through that credit check through the Apartment Owners Association, which in fact, I was just having a conversation with you, Jeff, of the new procedures that you're going to be instituting to catch the fraud of these applicants. And really, I take my hat off to you guys. You guys are great. But run that credit check through this association and get 2 months security, and you're far better off than 100% that you'll not make 1 penny on that property. Couple more, Jeff.
All right, here we go. This is Douglas from Manhattan Beach. LA County tenants are not paying due to COVID. Do you recommend we landlords create a repayment plan agreement or not? Great question.
I'm sorry, one more time?
Should they create a repayment plan?
Yes, I mean, I think it makes sense for the landlord to approach the tenant and to issue have a dialogue with that tenant. Hey, you know, you owe this money. It's not free. You're going to have to pay me. Why don't we start a payment plan where you'll be paying current rent as it becomes due and some money? Or maybe the landlord wants to step up to the plate and say, I'll tell you what, pay me all the rent you owe me and I'll give you a 25% discount. Probably better than waiting a year for your rent when the guy's not going to be there. So I do encourage landlords to try to make this. But again, tenant doesn't have to. Tenant can say, you know what, I know the law. I can just sit there for a year and not pay that past due rent. So.
Great. Okay, we take two more or one more?
One more.
Okay, here we go. Michael from YouTube. Or no, we got Daniel. Sorry, Michael. Daniel's up next. Tenant did not pay rent in the month of May 2020. He has paid also partial payments for the other months. Can I serve a 30-day notice to pay?
Well,
pay rent or quit. It's in the city of Sun Valley.
Okay, the Sun Valley comes under the city of Los Angeles or the county, depending if it was a single-family home. The answer is no. That rent is deferred and deferred for up to 1 year. With regard to all the other questions that you guys set in, first of all, thank you so much for participating. Those questions I'm going to be answering in the Apartment Owners magazine. They have a wonderful question and answer column. I know it's wonderful because I've been writing it now for 35 years plus. So I'll be answering those questions there, or you can always call our office at 1-800-77-EVICT or catch my website at evict123.com. I want to thank the Apartment Owners Association for this wonderful presentation. They really bring knowledge to our industry. And as Dan states, we really encourage you to donate to their political action fund because, quite frankly, we have to stick together. The politicians are not on our side. The media is not on our side. The tenants on our side. You know who's on our side? Only us. That's the only ones. So anyone, big shout out there to everybody, and thank you so much.
Right. And just to remind you, if you're a first time, never been an AOA member before, you can email your first and last name and your phone number to membership@aoausa.com, and someone will reach out to you as soon as we can. And so that is something that we want to do for you, and we hope that you're able to take advantage of that. And thanks again for joining us. We'll see you next time. Totally forgot the YouTube thing.